There's a lot of asset protection strategies out there, and you've probably read a lot about them on the internet. Hi, my name is Gideon Alper, and I want to talk to you just about 3 of these strategies that are very common and you might be interested in them. The first most important strategy in Florida involves the Florida homestead. In the state of Florida, your home is truly your castle. The protection of the equity in your home is in the Florida Constitution itself, and therefore it has a higher permanence and higher priority when competing with other state laws that the legislature might have passed, because it's in the Constitution. The Florida homestead applies to any home that is a ½ acre or less if it's located in a municipality, or if it's located outside the municipality, it's essentially unlimited. The value of the home doesn't matter. Your home could be worth $100,000 or $1 million, and it's still going to be protected. The second strategy that is often used involves tenants by the entireties. That's a special form of ownership between married couples. When a married couple has an asset, whether it's a bank account, real estate, an interest in a business, that is tenants by the entireties, the way to think about it is that the marital unit itself owns the whole thing together, and that interest cannot be divided among the spouses. To have a tenants by entireties asset, the asset must be acquired after the couple's married. It has to be acquired at the same time, so what you can't have is where one spouse acquires the interest and then later on the other spouse comes in on his or her own. And finally, it has to be acquired in the same document. Once you have an entireties asset, that asset is going to be protected from any claims against just one of the 2 spouses as a creditor. But note, if both spouses are the judgment debtors, so if the judgment's against both of them, then tenants by entireties affords no protection. The third strategy I want to talk to you about is an LLC. And that's something you've probably read a lot about. You'll see there's Florida LLCs and Nevada LLCs and LLCs in many jurisdictions. But if you're in Florida, you might as well form a Florida LLC, because Florida law is going to apply to you if the creditor is trying to collect on their judgment in Florida. An LLC is typically used to protect business interests or real estate because a creditor can only get a charging lien against the LLC as long as there's another member. That's what a multi-member LLC is, just more than one. If you have these assets in the LLC that aren't necessarily regularly making distributions and you're not relying on these distributions, then the asset is effectively protected while it's in the LLC. Note that it's important to have an operating agreement for the LLC that has customized asset protection provisions. These provisions will govern the restrictions on transfer of any LLC interests. It'll stipulate what a creditor with a charging lien is allowed to do and whether they're allowed to gain access to the financial records and voting interests of the LLC. And you want to be able to hold off a judgment creditor with a charging lien against those interests in the LLC. The asset protection operating agreement can help you do that. If you're interested in about any of these strategies that I've talked about, or perhaps any other strategies you've read about on this website, I'd like you to give us a call. Our number is 407-444-0404. And thanks for watching.